Okay, welcome to this Friday the 15th of May, employment law live stream. I hope Friday is going well for you so far. So hopefully, obviously there's a huge interest in employment law, and I would do a lot of employment law. Hi, Laura. I do a lot of employment law, and obviously it's an area of law that has a huge amount of interest in it. So if you might stick in the confirmation there on the live chat that you can hear me okay and see me okay. I think the camera is okay and the sound should be all right. If you have any questions, as I say, about employment law or any issues, whether you're an employer or an employee, I would be happy to try to deal with them as best I can. Obviously, I'm going to be given broad guidelines or general guidance, because clearly any specific area is something, any specific issue is something that will depend very much on the particular circumstances. So if you have a question, I would look forward to seeing it, and you might stick something in the live chat stream there as well as to where you're from perhaps and what you do. But so far nobody seems to have joined me at all, which is a pity. So I'm hoping obviously that you can see okay and hear me okay. Normally there's quite a few people there. I'm just wondering whether I am live on YouTube. I think I am, and I don't think there is any issue there. So if you have an employment question or any issue to do with employment, as I say, I would be happy enough. Ed Horgan has joined me there. He says I am, whatever that is. I presume I'm visible and audible and so forth. And Laura Merriman has a question on Instagram. Is there a legal requirement to have all settlement agreements confirmed by an independent solicitor, or is it just good practice to do so? It's good practice to do so, Laura, and from an employer's perspective, it is very much advisable, because obviously the agreement will be overturned or could be overturned or challenged if the employee later claims to have acted or signed up under duress, or they didn't know what they're doing, or yes, they were advised to get independent legal advice, but didn't in fact do so. And I have seen cases, and I've seen plenty of cases where employers or employees rather have gone back to the WRC or the Labour Court or wherever and looked to set aside the agreement and have another bite of the cherry. So the bottom line is, from a legal perspective, and certainly from an employer's perspective, it is good practice. It's not a legal requirement, but it is good practice, and it is a very sensible thing to do, because otherwise you are leaving yourself open. And that's why a lot of employers will, and I do a lot of settlement agreements myself, and I advise employees and employers indeed about settlement agreements, but a lot of settlement agreements, or most settlement agreements, obviously will make provision for the solicitor being paid by the employer. And quite frankly, the employer might be dissatisfied that they have to pay the employee's legal advice fee, but it actually makes a good lot of sense, and it gives them a certain degree of protection. So that is, I hope that answers your question there. When will the WRC resume? Ed Horgan says. I'm not sure, Ed, but it'll be a while, I'd imagine. And obviously, when it does resume, there's going to be a fair amount of a backlog. There's going to be a list to go through, because I had personally myself quite a few cases prior to the shutdown, and obviously they have to take their place in the queue, as it were, when things come back to normal. And at the moment, we're getting correspondence there from the WRC looking for consent to communicate with us as representatives by email, and that's because the WRC is not fully functioning. I'm not sure that the offices are open at all. I'm not sure whether post is being collected or being checked or whatever, but I'm getting emails there regularly from the WRC looking for consent to simply communicate by email. So that being the case, it's hard to see exactly how quickly, or see them coming back very quickly. Michael O'Donnell, how would the WRC treat a company that refused to release documents in relation to my dismissal or respond to correspondence with my solicitor? Would they take exception to this, or is it part of the game, so to speak? The WRC will probably draw their own inference from it, but whether anything turns on it or not is another issue. The WRC will obviously have a look at the correspondence between the parties, especially if the employee is either representing themselves or has a representative, and they're basically saying that they've tried to progress the case as best they can, and that they have sought various information and documents and so on from the employer, and the employer has failed to comply. The WRC adjudicator, the particular individual adjudicator, will draw their own inference from it, but it may or may not be of significance. And obviously, it may or may not be of significance in drawing a conclusion as to who's coming to the table with cleaner hands and so on. But it's something, you know, obviously you can make a data protection request, and that's an issue that is going to have to go to the Data Protection Commissioner's office if that's an issue. And I'm not sure whether that's going to be of any benefit to you on the day of the WRC hearing. So, as I say, in summary, they'll draw their own inference from it, and the employee and indeed both parties need to get their house in order before they go ahead. Laura Merriman has another question there. Eugene has joined. What changes do you think you need to be made in relation to the WTA to support remote working? How can employers prove employees aren't working beyond the required number of hours in line with the Act? Yeah, the whole question of remote working and so on is a messy one. In fact, it's difficult enough to ensure that employees are not working, etc., beyond, you know, the hours that they're supposed to be doing and so forth. The corollary of that question, obviously, is that the employer might be concerned that the employee is actually doing sufficient hours, or indeed is cooperative, or is efficient and working well and so on, and not just swinging the lead. So there is a balance to be struck there. Clearly, a huge amount of jobs as well cannot be done from remote working. Some can. I could work at home, for example, if I had to, but obviously many employees couldn't. For example, retail staff, or anybody working, for example, in, well, most people working in the likes of dentists or beauty salons, hair salons and so forth, you know. There is a difficulty in terms of employees basically overworking, etc., but I don't think it's too big an issue. And obviously there's an element of health and safety. There's an obligation on the employer to ensure the health and safety of employees, but employees also have an obligation to ensure their own safety and health and so forth. And obviously they are assuming a certain amount of responsibility and a certain amount of liability if they don't take their own breaks and if they work excessively and so on and so forth. But clearly the employer has an obligation as well to give whatever guidance they can give and so forth. But employees were overworking by reason of doing remote working, I don't think is a big issue. I think the bigger issue is that they're actually doing what they're supposed to be doing. Dean Carney is joined me there on Instagram as well. So I hope that answers your question there, Michael. As I say, when the WRC will resume, I'm not 100% having the bulls, and clearly there's going to be a massive backlog when they do come back. So the whole question then of redundancy and constructive dismissal and layoffs and so on and so forth is fairly important at the moment, and it's at the top of a lot of people's minds. And I know a lot of people who have been working from home, and Myrna has joined me on Instagram. I know a lot of people who have worked from home or have been working from home for the last few weeks and have been happy to do so and have enjoyed that sort of lifestyle. And some people I do know as well have been would be anxious to avail of redundancy if it was available. Now, that's not necessarily the situation insofar as you cannot, as an employee, force the employer. You might like the employer to make you redundant and pay you off and so forth, but you cannot compel the employer to make you redundant if your position is still there and if the employer still needs you. But I do know from the perspective of many employees for the last little while, they have been happy enough to work from home, and it's perhaps been an eye-opener in terms of the quality of lifestyle and so on. Obviously, there's other people then who are happy to go back to work. So, but in terms generally of redundancy and forcing the employer or obliging the employer to basically pay you off, they don't have to do that. You can't force them to do that. Ultimately, the question of redundancy is one that the employer has to decide upon, and the question of forcing redundancy has been suspended with the emergency measures taken by reason of the COVID-19 shitstorm in the last while. So the question of the employee serving a notice of redundancy on the employer has been suspended. That's part of the emergency measures, the emergency legislation that was brought in as a result of the COVID-19 situation. Any advice to someone who would want to change solicitor? I've already brought my case, but I have some reservations. Is it too late to change solicitor once a case is brought to the WRC? No, there's no difficulty changing solicitor once you bring a case to the WRC, but the solicitor will not release that file unless and until they're paid. And they have what's called the solicitor's lien on the file, so they're entitled to hold on to the file unless and until they're paid. So if you want to change, there's no problem, but you will have to discharge the fee of your existing solicitor. But generally, you're entitled, obviously, to have anybody you like representing you. But as well as that, the solicitor is entitled to be paid for the work they've done. And obviously, I'm not privy to exactly how much work they have done, but that's where you're at there. They won't release the file unless they're paid. Andreas Antonitis likes my live videos. Quick question. For the purposes of Working Time Directive and 1997 Working Time Act, what is the definition of overtime for the purpose of annual leave pay? The definition of overtime, I'm not sure whether the definition or overtime is defined in the Act or not, but obviously it would be time spent working over and above, I think, the contracted or contractual hours. So obviously, if the contract says that your normal working week or your contracted hours is 39 hours or 40 hours a week, then anything in excess of that, I presume, could be classified as overtime. And that's really what you'd be doing there. You'd be looking at the contract. Now, you could look at the Working Time Act, the Organisation of Working Time Act 1997 or whatever year it is, and see is there a definition there. It'll be in the early section, section 1 or section 2, in the interpretation as to what is overtime. But I think generally it wouldn't be a big job to prove what is and isn't overtime in any particular situation. But clearly it will depend on the particular contract of employment. Specifically, I'd like to know if your contract specifies 30 hours of work, is anything above 30 hours counted as overtime, or maybe there is another cutoff? Yeah, I think if your contract specifies that you are obliged to do 30 hours a week and you have a contract for 30 hours a week, then you're entitled to believe that anything over that is overtime. However, there's no guarantee. Kevin Loonan, how are you? There's no guarantee that you're entitled to be paid for overtime. In fact, you might get time off in lieu of working overtime, or you might be paid at a standard rate or double rate or time and a half. But it is possible, and there's no legal obligation, it is possible that you won't actually be paid for overtime. And if you're on a salary, for example, that is a dispute that always arises. In other words, if somebody is on a salary and they might be working in an industry where salaries, for example, managing a hotel and you're a receptionist or you're a hotel manager or you're a commie chef and so forth, if that is the situation, then the likelihood is you're on a salary and you're not going to get paid for each hour you work. And quite frankly, when you go into such an industry, you're going to be expected to understand what the custom and practice is in that industry. What is the most common employment law issue you deal with? Common employment law issue, I suppose, unfair dismissal or dismissal, but also from an employee's perspective, a lot of allegations of bullying or harassment, that sort of thing. But generally, the question of bullying or proving bullying is hugely different from what is generally perceived by employees to be bullying. In other words, employees will often throw around or bandy around words like bullying and harassment in situations where all they have is a haymaker of a grievance or an issue or a chip on their shoulder, perhaps, or some other issue with the employer. But it may not be bullying, it may not constitute bullying. So that is something. But generally unfair dismissal, constructive dismissal, sometimes discrimination, and sometimes redundancy. Settlement agreements, then I do quite a lot of settlement agreements as well, where employers are letting employees go, making them redundant, or negotiating the termination of their employment. And in those situations, a lot of employees come to me and ask me to review the agreement. And obviously I'll do that. I'm happy enough to do that. But just to go back to the bullying word is something that's bandied about and thrown about like snuff at a wake, quite frankly. And it is difficult to prove bullying. That's not to say that it doesn't exist, but I mean, it is repeated inappropriate behavior that offends your dignity. But I mean, if you ask for a day off next week and you don't get it, or if you expect or think you're entitled to a bigger bonus than you got, that's not bullying. That's, decisions by management, etc., to meet the needs of the business and so forth. But it's not bullying. So people get confused about that. Michael O'Donnell, I was never given my 6 weeks notice. I was on a 6-month probationary contract. I was only told I had a HR meeting and dismissal responsibility. Is that considered a valid notice? The valid notice is whatever is contained in your contract of employment. And most probation clauses in contracts of employment should have a notice period that is much, much less than the normal notice period. And if I was drafting it, quite frankly, the notice period in the probation period would be 1 week. So whether you can do anything about it or not is another thing, because when you're on probation, quite frankly, you are in a very, very weak position. And all you can do is go off to the WRC with some sort of a complaint about discrimination or whistleblowing or something, which doesn't require 12 months service, because without the 12 month service, you don't have an unfair dismissal claim. And quite frankly, if you're going to the WRC on an unfair dismissal claim and you were dismissed during probation, etc., then you're going to have a difficult time justifying your time and effort. Mark K&S McGuire joined. Hello, Mark. How are you? Emmett Duffy, great videos, Terry. Very informative and useful. I'm in HR and find these videos invaluable. That's good. Laura Merriman, what are some of the most interesting WRC decisions you've read this year? Were there any that surprised you? There has been a few that surprised me, but one of the most interesting ones was a decision that I got there recently myself for a client, where we got 2 years salary for discrimination. The fella was dismissed when he was out sick, and we brought a claim for a discrimination-based dismissal. I've written a blog post about that, and it's on my website, and I'm not sure whether the employer is going to appeal or not, but 2 years is the maximum for discrimination-based dismissal, and that was one of the most interesting WRC decisions that I've seen, and it's only in the last few weeks that I saw it. I was very, very happy with that. There has been some other interesting decisions, and some of them, quite frankly, have to do with unfair dismissal, where you would have thought that the employer was justified in dismissing the employee. And I can't recall any just off the top of my head, but I have seen situations where managers, for example, have sexually exploited employees. I've seen situations where Managers might have assaulted fellow employees, or might have done some other ridiculous behaviour that could only be constituted or described as misconduct or gross misconduct, and yet they've won unfair dismissal claims. And the reason they've won is because of the absence or lack of fair procedures and natural justice by the employer. In other words, even in the most egregious situation, even in a situation where the employer would be perfectly justified in getting rid of the employee by reason of misconduct or gross misconduct or anything else, then the employer has still an obligation to go through some sort of fair procedure, natural justice, put the allegations to the employee, give the employee the opportunity to explain, and so on. They must go through these very, very rudimentary procedures, disciplinary procedures. And they doesn't have to be perfect, but they do have to be fair, and they do have to basically say to the employee, look, at this sort of carry on or conduct is inappropriate and unacceptable. What do you have to say to it, or what excuse do you have? So, you know, the medication that you're on mightn't have agreed with you or something like that, and you might have a valid excuse, but you should be given the opportunity, no matter how reprehensible your conduct, most of the time, to explain yourself. The Nighttime Entrepreneur. Hi, Terry. Been a fan for a while now, and also working with popular Irish HR software. Good stuff. We're looking at releasing useful docs to the legal sectors, HR and owners who are going to have staff back in soon. Good for you. If you can think of needs in the area, please let us know. Well, I will. I was told that multinationals, Michael O'Donnell is saying in particular, are inclined to settle if a WRC case is appealed and goes to the Labour Court to avoid adverse publicity. Do you think that view is right? It depends who the multinational is, and it depends what's at stake. I mean, clearly, some cases are well worth appealing, and sometimes the threat of publicity or the threat of a hearing in public, and the Labour Court hearing is supposed to be in public, is something that will have a persuasive effect on employers and persuade them to perhaps dodge the bullet of any publicity and settle the case, etc., etc. But quite frankly, a lot of employees overestimate the value of the threat of adverse publicity. In other words, for the employee in question, it is an absolutely huge issue. It's an absolutely monumental point in their life. But quite frankly, for the rest of us, for ordinary people going about their daily life, the fact that somebody has been dismissed unfairly or otherwise isn't of huge consequence. So a lot of employees, I find, do over-egg the pudding and do overestimate the value or the value of the threat of unfair or adverse publicity. Having said that, some multinationals and some big employers aren't fully aware either, and when they're told that, you know, Labour Court hearings are in public, whereas WRC hearings are not in public, then they might be more inclined just to settle it. There's also the question, not just of adverse publicity, there's also the question of the cost of defending a case or defending a case if you're the employer at the Labour Court, because obviously there's legal costs involved and it can get expensive. And, you know, some hearings either at the WRC or at the Labour Court can take on a life of their own and can go into second days and third days. And all of that obviously will depend then on the number of witnesses. Inspired Hairdressing joined. Hello, Inspired Hairdressing. I think I know who you are. But yeah, the threat of adverse publicity is something that, you know, some people think it's a huge, big stick, but sometimes, you know, no one cares, quite frankly. And that is unfortunately the situation. The question obviously then is the question of how much what the potential payout is. I mean, if you have a Mickey Mouse claim, quite frankly, and the very most you're going to get is nuisance money, then, you know, for $5,000, etc., they might or might not be inclined to settle. But having said that, if you're only going to get $5,000, then it's quite possible that they might take the view that it'll actually be more expensive for them and more costly to engage the services of solicitors. So, hi, Inspired Hairdressing, how are you? So that's the story there. I'm surprised there's not more questions coming in there on my YouTube live stream, because I get a huge amount of questions every day, and a lot of employees expect me to advise them and answer questions for free, but it can be very difficult and very, very time consuming to do that on a daily basis, because it can be very disruptive and interruptive, and I do get a huge amount of them. Obviously, I have a fairly high profile from a social media perspective, and I generate a lot of queries and a lot of questions and so forth, but I do reserve the right to charge for my services, etc., and I am slow enough to give free legal advice. And the reason for that is very simple. If I give legal advice to somebody and they go off and it turns out badly for them, regardless of whether I've charged for the advice or not, whether I've got paid for the consultation or not, they can still probably sue me for professional negligence, because even though I haven't been paid, I am a solicitor, and if I give them advice, they should be entitled to rely on it. And even though they mightn't have paid, even though they've got free advice, the likelihood is they can sue me. Now, if that's the case, by all means, fire away and sue me. But if that's the case, then I reserve the right to charge in the first instance, because if nothing else, it's going to contribute towards the cost of me having professional indemnity insurance. There's also the question of time and the question of looking at the particular circumstances, the facts and the law surrounding any individual situation, and that can take time. And often what appears to be, to the ordinary person, a very straightforward case or a very straightforward question is anything but straightforward. And it really does require the perusal and review of documents and so on and so forth in order to advise properly. What's the favorite part of your job? I like my work, Laura. I don't know. I just like it generally, I suppose. I like the law. I've always liked the law. I haven't always been in law, but I do like it. And I suppose assisting people and helping people and getting a good result, like from time to time, really rings my bell. And sometimes as well, you might take on a case where you really feel that an injustice has been done. An injustice has been done to the employee or the employer, but generally it's the employee, quite frankly. And you really feel like taking on the case just for the sake of it, because you feel a sense of grievance, a sense of injustice, a sense of wrong, and a sense of being able to perhaps help somebody who isn't all that tuned into the law and so on to get sort of justice. Now, I wouldn't take on too many cases for free, quite frankly. I wouldn't work on a no-fault, no-fee basis too often. But from time to time, some case will come along that is an absolute haymaker of an injustice, a haymaker of unfairness. And in those situations, I'll say, screw it. I'll just help this fella or this girl or whatever. And to be honest with you, I have one such case at the moment. And I'm going to do it, even though it's probably not going to be a paying proposition. And to be honest with you, it's up the other part of the country completely, but I will do it because the way this fella has been treated has been very, very poor, very, very shabby. So sometimes you're motivated by a sense of injustice, and sometimes, but generally I just like the job, you know. Now, Inspired Hairdressing on Instagram. With regards contracts handbook, what extra do we need to add now when returning to work relating to COVID, etc.? Also, do we need to do health and safety training relating to COVID? Inspired Hairdressing, if you go to my website, employmentrightsireland.com, I did a blog post there in the last couple of days, I think it was at the weekend, about there's a return to work safety protocol or COVID-19 protocol. Have a look at that, go through that. So that is a protocol from the Department of Health and I think the Department of Employment Affairs and so forth, explaining what employers should be doing to ensure a safe workplace, etc., when they return. If you follow that protocol, you'll be all right. aside from that protocol, obviously there's a contract of employment and there's a staff handbook, and you have to do the best you can. Clearly, you're not an insurance company and you can't provide an absolutely bulletproof work environment or work situation. So as long as you follow the guidelines, you will be discharging your duty of care. You do have a duty of care as an employer. There's a standard of care. It is not perfection. It is that you follow the reasonable guidelines from the Department of Employment Affairs, Department of Health, and so on in the COVID-19 situation, and that you follow along with and adhere to the contract of employment and the staff handbook. Leighton Penrose has joined. Hello, Leighton. How are you? Mr. Dave, what do I need before contacting you about a personal injury claim in the workplace? Mr. Dave, you need to have suffered an injury. So it might appear trite, it might appear facile, but you need to have suffered an injury. And if it's a personal injury, fair enough, that's, you need an injury. And basically the injury then, the degree to which you're injured, the severity of your injury, that'll be substantiated by a medical report. So you need to have suffered an injury and you need a medical report. Laura Merriman is asking, what's the difference between a furlough and a layoff? As far as I understand, Laura, furlough or furlough or whatever it is a UK situation. It's very similar to layoff, but in Irish law, I haven't seen any reference to a furlough as such. It's a layoff, or it's short time, or it's redundancy, or it's a termination of employment, whatever. But I think furlough is a UK definition, I presume, in UK law. I wouldn't be 100%. Speaking of personal injury in the workplace, I've had one or two cases of psychological or psychiatric injury arising from the workplace. And these cases can be very expensive for the employer. However, a lot of employees take the view that they have suffered a psychological or psychiatric injury and can bring a personal injury claim by reason of the stress in the workplace. What they don't understand and they fail to recognize is the difference between ordinary workplace stress, which is perfectly understandable and accepted widely by the courts and everybody else, versus the type of stress that will overbear your mind and cause you an injury. There is a world of difference between the two. So ordinary workplace stress it comes with the territory. You're supposed to be stressed, quite frankly. It is not play. It is not recreation. It is not going to Vegas and going to a casino. It's not going and playing hurling or football or golf. Workplace is supposed to be stressful. What's not acceptable is the type of stress that'll overbear your mind and cause you an injury. That's a different ball game. And that will depend on a consultant psychiatrist report or a psychologist report identifying and confirming that you have suffered an injury, a recognized injury. If you can do that, and if your medical report can do that, then you might be off to the races. Then you might be able to pin the negligence on the employer. But it's not easy. It's not easy. But I get a lot of employees, quite frankly, from time to time, telling me that they're suffering from stress and they want to sue the employer, etc. But as I say, stress does come with the territory. It does come as part of being an employee. It does come with the job, as it were, a certain amount of stress. That's understandable. Michael O'Donnell, I'm pursuing a discrimination dismissal case on the grounds of mental health. I admitted I had a stress disorder. I was told all this correspondence between the occupational health doctor and my supervisor were probably put in the shredder. Can the WRC judge a company on a lack of paperwork? Michael, this is the same question as you asked me earlier on there. The WRC will draw their own inference. The adjudicator will draw their own inference from the way that each party comes along to the proceedings and what they've done in terms of documents and documentation and so forth. So they'll draw their own inference, and I don't know why documents would be put in a shredder, but quite frankly, after a certain period of time, it's inevitable that documents will be put in a shredder and but after a certain period of time. So I don't know the difficulty, or I don't know the exact details of your situation, but the adjudicator will, and they're very sensible, quite frankly, and they know the law as well. The adjudicators will make their own conclusion, or draw their own inference from the way parties go along to the hearing. Cat 12 Jack sent a request to be in your live video. Not sure what the story is there now, Cat 1 Jack. I'm not all that. I'm not sure how that works. Anyway, as I say, the supervisor was probably putting the shredder or the paperwork. The adjudicator will draw their own inference, Michael, and they will draw their own conclusions, and they will make a decision. My experience from adjudicators, quite frankly, is that they know the law, and if you're not happy with the outcome, you can always appeal it to the Labour Court. And obviously, if you're not happy with the way the Labour Court conducts the hearing, you can appeal that then on a point of law, and on a point of law only, to the High Court. I wrote a blog post there the other day about the situation, appealing to the High Court from the Labour Court on a point of law. And on my employment law, or my employmentrightsireland.com website, the most recent blog post I wrote, I think, was about the appeal from the Labour Court to the High Court on a point of law. And some people or a lot of people are confused about what that actually means. It means that unless the Labour Court has misinterpreted the law, or unless the Labour Court has arrived at conclusions of fact that are perverse in relation to the facts that were put forward, or the evidence that was put forward, unless the Labour Court go off piste altogether and fail to interpret the law correctly, provided that they hear the parties, and provided that they then make their decision based on the evidence from the parties, then that is the job of the Labour Court, and the High Court will not interfere and will not get involved in the substantive issue of any particular dispute. So that's the story there. No more questions there on Instagram. Cat 12 Jack. So I'm surprised there isn't more questions there. There's normally a lot of questions. I get them in my email there all the time about bullying and so forth, but there doesn't seem to be too many today now. But the WRC, basically they'll make up their own mind, and they will draw their own conclusions about the way each party comes forward with their own case, and what sort of evidence to put forward, and how they deal with the other party, and so on. And in relation to the COVID-19 situation, as I say, all you can do is discharge your duty as best you can and follow the return to work safely protocol that's put forward there by the Department of Health and the Department of Employment Affairs and Department of Welfare, or whatever you call it. But if you go to my website, employmentrightsireland.com, I've written about it there. It's a brief summary of the situation, the return to work protocol, but there's actually a link in the blog post to the actual document itself, and it is useful, it is helpful, and hopefully it'll help you when you're returning to work. I know that your game is hairdressing, obviously, and you've been badly affected by this whole situation. What process do I follow when creating a submission for WRC? The question of creating a submission or doing a submission for the WRC is one that there is different opinions about. Some people hang back and don't put forward their best foot, and hang back on the basis that they might surprise the other side, or not show them their full hand, not show them their entire case. What I do is I prepare the submission. I'll send it in advance to the WRC. I'll send it to the other side, and I'll take my chances there on the basis that if I send it in early enough to the WRC, the likelihood is, and I've learned this from experience, that the adjudicator will have read my submission before the hearing. And if the last thing that the adjudicator reads before the hearing is my submission, and the other side hasn't put in a submission, I feel I have a slight advantage because I've put forward my story. I've set it out in easy to read language for the adjudicator, and they've read it, hopefully. Now, they don't always read it, but they do often. And if they do, then I'm happy, because if the other side comes along with a big submission on the day, then it can be difficult to impart all of that information and everything that you want to say to the adjudicator on the day. Secondly, it can be difficult for the adjudicator in the hurly-burly of a WRC hearing to actually take in and assimilate everything that the other side is putting forward. And that being the case, I think on balance, and it is a balance to be struck, and it's not straightforward, but on balance, I think it's a good idea to get the submission in, and I hope that the adjudicator will have read it. As I say, I've come across plenty of adjudicators who have read the submission, who have clearly read the submission. I know they've read it, but I've from time to time met one or two who claim that they didn't receive the submission, and that's fair enough. Perhaps some administrative gremlin got into the situation and they weren't given the submission. And that being the case, they mightn't have got the chance to read it. But that's what I would say, Laura, that what I do is I prepare the best submission I can and get all my ducks in a row, put my best foot forward, and generally, to be honest with you, the facts will stand for themselves. And if I have the facts on my side, if the evidence is on my side, then I'm in a strong position. Because if you give me a choice between the facts and the law, I will generally take the facts. In other words, if the facts support my case, then the other fella or the other person can know everything about the law, but the bottom line is the facts are the facts. And if a fella, for example, or a girl was unfairly dismissed, then it's going to be fairly evident from the facts. Max, I got let go when I was in hospital. Is it better to take unfair dismissal, discrimination based on disability? Depends on the circumstances, Max. It depends on the exact situation. So let me explain. I had a case like this recently and I've written about it, and I had a choice, and I've written a blog post and I've made a video about it. I had a choice of bringing an unfair dismissal claim, and this is going to help you. I had a choice of bringing an unfair dismissal claim on behalf of a client or a discrimination-based dismissal on behalf of the client. So that was a choice between the Unfair Dismissals Act 1977 or the Employment Equality Act 1998. I chose the Employment Equality Act 1998. Why? Because the employee in question had got a new job fairly quickly, had got a job within a month. Therefore, if I brought a claim for unfair dismissal and if I was successful on behalf of my client, then the most my client could have been awarded would have been 1 month's salary, because his financial loss was only 1 month. Whereas for the discrimination-based disability dismissal, you can be compensated, the employee can be compensated for the act of discrimination. Therefore, he could have been and was awarded 2 years' salary. So that is the situation. Your situation will depend, therefore, on whether you got a new job fairly quickly or you didn't. So if you didn't get a new job for, say, 9 months, then you have potentially 9 months loss of earnings. And if you have a good unfair dismissal case, well and good, then you're looking at perhaps an award of 9 months salary if you're successful. However, if you got a new job within a fortnight, then forget about unfair dismissal. You'll be looking at the discrimination-based claim, and that would be for the act of discrimination, and it would be on the basis that you had suffered a disability at the time. Cat12 Jack on Instagram. I was out of work sick for 2 years, recovering from cancer, and my employer let me go because they were trying to contact me by post, but the whole time we're sending these letters to the wrong address. I don't know when that occurred, Cat12 Jack, and it's unfortunate, obviously, that they terminated your employment and sent the letters to the wrong address, etc., etc. Obviously, it was open to you then to bring a claim for unfair dismissal if you felt you were unfairly dismissed. There is a procedure through which the employer would be well advised to go before they would terminate anybody who was out sick for a good while. And generally they would need to put the employee on notice that they are thinking about terminating their employment on the grounds of incapacity. That is, the employee, unfortunately, is unable to perform the contract, and therefore they could only do that and terminate the employment after warning you that your position was at risk by reason of incapacity. And the bottom line is, they would, or should, if I was advising them, invite you to put forward your medical evidence or your appeal if you felt that you were being unfairly treated, and in fact, if you felt that you were being unfairly dismissed. There is a procedure, and that's what you need to do. So basically, the employer will be claiming that by reason of incapacity, then you are going to be terminated, and you, as I say, would put forward your own medical evidence. If the medical evidence from the employer's solicitor or the employer's doctor or medical advisor was wrong, then you'd put forward your evidence to say, no, I'll be able to go back to work in a month's time or 2 months' time, and I am asking you to keep my position open. If you were to, hello, Paul Barrett, 20. If you were to bring a claim there, you'd be bringing a claim perhaps or probably for a discrimination-based dismissal. So it would be a discriminatory-based dismissal under the Employment Equality Act 1998. I don't know what you did, and I don't know whether it's too late now or not. Generally, you must bring all claims within 6 months of the alleged transgression or breach of the law. Pause animal services. What is precedence when a judge in court says there is none? Also, when a lay litigant is taking a case to the WRC, do they need previous case law to prove their case? Question for a friend. Thanks. If you're bringing a case to the WRC, you need to prove two things. One, the facts, and two, the law. So the facts, you must prove that. Adrian Morrissey, how are you? You must prove that you were, for example, unfairly dismissed. And this should be fairly easy to prove from a factual perspective. Proving the law then is fairly straightforward. You look at statute and you say there's a breach of the Unfair Dismissals Act 1977, blah, blah, blah. And here is precedence, or here is a case law to support my case. Yes, it is useful to have case law, and you can have it all printed out and bring it with you, or you can simply refer to the cases. But quite frankly, the adjudicators know their cases or know the law fairly well. So if you went along with an unfair dismissal claim to the WRC, your friend did, for example, and I know you're asking this question for a friend, if you went along and you didn't have any case law, you'd no case law whatsoever, what could the adjudicator do? Could he throw you out and say, no, you're not going to win this case now because you don't have any case law? I don't believe so. I think the adjudicator will make his or her decision based on the facts and based on what the adjudicator knows to be the law. So the question is, where was your friend, for example, unfairly dismissed or discriminated against or whatever? Then the case law, quite frankly, is irrelevant to a great extent. However, there may well be a case, for example, which will involve an argument about the law. For example, duplicate proceedings or parallel proceedings, where an employee might bring a claim under the Employment Equality Act 1998 and under the Maternity Protection Act 1994. The question then arises, and I saw it recently there because I've written a blog post about it. The question arose where the HR manager was returning to work after maternity leave, and she brought a claim under both acts, the Employment Equality Act and the Maternity Protection Act 1994. And in that situation, the argument rose that the employee couldn't claim under both acts, but the adjudicator held and found that he could or she could award claims or make awards under both acts. Now, there was obviously a legal dispute there. There was an issue or a row or dispute about the law, and each side would have put forward cases and case law and high court case law and so forth in support of their argument. But that was an argument about the law and parallel proceedings and duplicate proceedings and so on, whereas a straightforward case of unfair dismissal or non-payment of wages or discrimination, etc., probably won't require a huge amount of case law and probably will be decided basically on the facts And if I was a lay litigant, I'd have no difficulty going in for into the WRC and putting my case in the hands of the adjudicator, and I'd be expecting to get a fair shake. Gwen MCK has joined. Hi, Gwen. Paws Animal Services also says, what is precedence when a judge in court says there's none? I'm not sure what you're referring to there, because in a WRC hearing or an employment dispute generally, unless you're suing for breach of contract or a personal injury claim, you're not going to be in court with a judge. You're going to be in the WRC or in the labour court. The question of precedence, etc., I'm not really sure now where you are going with that, but that's what I'd say there. Now, sometimes, as I say, there will be a sort of an arcane legal dispute or legal argument or legal debate to be had, and that's fair enough, and I've been involved in a few myself. And if that's the case, well, then obviously you're going to be looking for case law to support your argument, and you're going to be looking for case law to put forward in support of whatever proposition or whatever thing you're asking the employer or the WRC adjudicator to decide. So let me see now. Any more questions there? No more questions. God, you're very slow with the questions today now on the live chat. I had more questions about property. I thought I'd be absolutely hockeyed out of it with questions on employment law, because people are always asking me questions about employment law. And obviously, it's a huge area of law and it's a huge area of my practice. And the reason for that is because there's a huge amount of employees in the country. So for every employee or for every conveyance or property transaction or personal injury claim, there's an absolute buttload of employees with queries and grievances and issues and so forth, and questions to do with redundancy and layoffs and alleged bullying and alleged discrimination and grievances and so on and so forth in the workplace. But I would have thought I would have had more questions about employment law. Michael O'Donnell is asking, how would an off-the-cuff remark be treated in a dismissal hearing? Settling it, would it be of any consequence? I'm not sure, Michael, what you're asking there. Obviously, an off-the-cuff remark, it depends on whether it's on the record or not. Depends on whether it was with a view to trying to settle a case or not. Not sure what the context is there. But I would just caution generally that WRC is a relatively informal sort of a procedure. It's not a court of law. It is relatively informal, and there's a certain degree of latitude, a certain amount of argy-bargy, quite frankly, allowed, and it will depend on the adjudicator as to how they conduct the hearing and so on. But a lot of adjudicators let a lot of stuff go, and other adjudicators run things in a more strict, regimented sort of a way. It really depends who you get on the day. And in relation then to the administration of law, I wrote a blog post there last week about the High Court challenge, the judicial review challenge to the constitutionality of the Workplace Relations Act 2015, the Workplace Relations Commission procedure, and the Labour Court procedure. And that was challenged in the High Court, and it was challenged on two grounds. One, that they were involved, the WRC was involved in the administration of justice, and the Bunrock Heron, the Constitution of Ireland, says that the administration of justice must be held in public, and WRC hearings are not held in public. And secondly, the procedures involved the applicant to the High Court in proposition or in support of the proposition that the Act was unconstitutional. One of the grounds was procedural grounds. That is, there's no automatic right to cross-examine witnesses. There's no procedure for taking evidence on oath, and there's no obligation on adjudicators to be professionally trained in a legal sense. However, the High Court rejected the application that it was unconstitutional on the basis that the WRC were not, in fact, involved in the administration of justice. And the reason for that was because when a WRC adjudication is finished, a decision or a recommendation emanates, but that decision, if either party chooses to ignore it, must involve an application to the district court in order to get a court order to enforce it. That being the case, the WRC is not, according to the High Court, involved in the administration of justice. And if it's not involved in the administration of justice, then it can adopt the procedures that are set out in the Workplace Relations Act of 2015 and so on. Questions are drying up now. I'll have to pull the plug now if there's no more questions coming in. I've only 5 minutes to go anyway, and I'm getting hungry, you know. I'm getting really hungry now, and I've had a couple of consultations there this morning via phone or video, and I have another couple in the afternoon. So, explicit IT guy, thanks Terry, absolutely amazing content. When is the next property related live feed? Oh, I might do another property related live feed, yeah. Not sure about that now, explicit IT guy, but I will do one, and not sure exactly, but I will announce it, obviously. Useful. Adrian Morrissey, question in chat above, thanks. I don't know where that question is, Adrian. I don't know where to find it either, quite frankly. Oh, wait, no. Here we go now. No. Adrian Morrissey says there's a question there. I can't see any question, Adrian. I don't know what it is. Question in chat above, thanks. Yeah, if you find this one useful, I'd appreciate it if you give it a thumbs up, because the Google or the YouTube algorithm would be impressed with all the thumbs ups and so on, and people liking my stuff. And if the algorithm sees a lot of activity and a lot of people liking the video and the live stream, well, then they'll surface it for more people. So obviously, you know, the more people that see it, the better from my perspective. And as I say, if you find it useful, find it helpful, give it a thumbs up, and don't be afraid to do that. As I say, Adrian Morrissey, I can't see any question in the chat above. Maybe I missed it. Maybe I missed it. Can't see any chat there now, or can't see any question there, Adrian, I'm afraid. Cat 12, Jack. It was December 9th, 2019. I was let go. I've been following you and your wealth of knowledge. Well, Cat 12, Jack, it's possible, I suppose, that you could bring a claim still, because you're not out of time if it's December 19. You're getting close to it, though, because generally you have 6 months to bring a claim for unfair dismissal or discrimination-based dismissal or whatever. So, Gwen MCK, I was just wondering about employee rights under COVID-19 scheme. Can they fire you if business is dropped and they don't have enough work for all staff? Firstly, if an employee or an employer has no work for employees, then yes, they can terminate your employment and they can make you redundant, quite frankly. So that's assuming that they don't have enough work. And that's really it. Redundancy is a defence, is a valid and legitimate defence to an unfair dismissal hearing, or dismissal claim, rather. So, you know, if they don't have work, they can terminate your employment. That's unfortunate. That happens. And there's a lot of businesses, quite frankly, going to be in a bit of trouble in the next while with the return to work, graduated return to work, graduated return to business, because it's obviously an absolute shitstorm for a lot of businesses, and it's very, very difficult for small operators. I've been lucky enough because I have been working away here behind closed doors. I'm so-called essential service, and I've been working away doing consultations by phone and video and email and Skype and Google Hangouts and Zoom and the whole lot. I haven't been too badly affected, but obviously the whole question of property transactions and so on has slowed down. And obviously I miss the actual interaction of people coming in off the house or coming off the street. Adrian Morrissey, purchasing first house next year. Good for you, Adrian. If you're purchasing your first house next year now, your timing could be good, because obviously the COVID-19 situation is going to probably affect prices. And there was the report last night on the news, or wherever, I think it was on the news, where KBC Bank did a thing yesterday, some sort of a presentation, an off the record or a presentation to economists or whatever, talking about perhaps perhaps a 20% drop in prices, but that is a worst case scenario. It mightn't be, hopefully not. Hopefully things will plod along. There's only 18 minutes remaining, or 18 seconds remaining there on Instagram, so I'll be going now shortly. But if you want to quote there Adrian Morrissey when you're buying the house next year, give us a shout. I have no problem doing that. And obviously I do all sorts of law, including property conveyancing and business and probate and personal injuries and so forth. Thanks for joining me. Yeah, I'm going to end the live stream there now. I hope you find it useful. If you do, you might give it a thumbs up down below. It helps me get the word out. It helps me grow my business. And you can hit the like button. Thanks for joining me. And hopefully you'll be with me for the next live stream. Not sure what it's going to be on. Maybe property, maybe business again. Maybe ask me anything. We'll see. So keep an eye out on my YouTube channel. Subscribe and give me the thumbs up down below. Thanks for joining me.